Nick Rekieta of Rekieta Law, small law firm in central Minnesota, ended up getting busted for having 26 grams of cocaine in his house back in May of 2024. So this year. The fact he had firearms in the home, well, you're not allowed to have firearms and illegal drugs in the house. Whether or not you agree with that or not, that is what the law currently is. And he was charged with that. He was also charged with having children in a home with a bunch of drugs as child endangering. Once again, you can agree or disagree, but that is currently the law. Now, the last two charges are misdemeanors. He faces up to a year in jail on those. The bigger charge is the 26 grams of cocaine, and he faces up to 25 years of prison on it. Now, would he ever get 25 years of prison? No. There's a lot of presumptions and a lot of statutory judicial interpretations that the worst case scenario he's looking at is some sort of probation sanction to begin with, and they would not send him to prison right away. So those of you who are worried about him going to prison, that's not going to happen. I've said that from the start. Those of you who are hoping he goes to prison, that's not going to happen. I've said it from the start. Nick challenged the search warrant on the grounds of the police lied, which is something he could challenge under a Supreme Court ruling known as Franks v. Delaware. And that's set out, and you've heard it talked about the Franks hearing. Well, Nick filed his motions, and if you've paid attention, I critiqued them. They were absolute hot garbage. One of them was disorganized hot garbage, and the other one was very well organized and streamlined hot garbage. So what happened? Well, the court looked at all of it and said, nope, Nick, you lose. You're done. We're not having a Franks hearing. I don't believe the cops lied or relied improperly on any information. In addition to that, Nick then was also precluded from raising any other issues because I know Nick's saying he didn't do it, but as Nick has mentioned, apparently his lawyers aren't the best, which I don't know why you're still using them, but it's just me. They missed a bunch of other things they could have argued, and then they're now precluded from bringing those issues up. So what happened from there? Well, Nick filed an interlocutory appeal, and we covered the interlocutory appeal earlier when it got filed. An interlocutory appeal is basically asking a court of appeals to make a ruling on a trial court ruling mid-trial, midstream. So literally you're like trying to hit pause on your court case and have the Court of Appeals figure out what it wants to do. Now, those are discretionary. You're not entitled to them. Now, there are times where there are very good reasons for it. So a very good reason of that was the Trump v. United States case about presidential immunity. Issues of immunity are kind of a big deal because if you're immune, then the case dies right away. There are times where you have very novel issues, or there's an issue that was clearly wrong, something like that, and even that it's discretionary. But those are more compelling cases. And Nick tried to make the argument, look, I've got a compelling argument. Well, the Court of Appeals offered its opinion, and they said, not so much, not so much. And we're going to take a look at that. It's only 4 pages long, but it says so very much. It's the state of Minnesota in the Court of Appeals. It's the Court of Appeals. State of Minnesota versus Nick Rekieta. And this was decided by a couple different judges, by Judge Segal, Judge Wheelock, and Bentley. So they said, based on the file, record, and proceedings, and for the following reasons. And then they go through the basics. Nick's charged with second-degree drug possession, unlawful possession of a firearm, and child endangerment. Based on evidence after a search warrant was executed at his house. And he talks about it. He moved to suppress the evidence and dismiss the charges under Franks v. Delaware. They want to investigate whether the search warrant application contained material misrepresentations regarding the social media video. Once again, we're getting back to Mo watermark. The district court denied the motion for a Franks hearing, and the petitioner seeks discretionary review of the order denying the motion for a Franks hearing. Remember, it's discretionary. The court could say, yeah, we'll take it up, or they could say no. This is not an appeal of right. After the trial is over, and after a case is over, your criminal appeal is an appeal of right, meaning you have the right to file the appeal, and they have to take it under consideration. Now, they may end up saying your appeal is garbage, but by law and by constitutional right in many states, you have the right to appeal at that point. You don't normally have the right to appeal midstream. So the petitioner argues this court should grant discretionary review in the interest of justice because the Franks issue is important and doubtful, and resolution of the issue would obviate the need for further proceedings. Now, here's the big thing. The state has not filed a response. Now, normally, when these types of things, the state probably should have said, like, Your Honor, we don't file a response, we waive it. They didn't even bother to do that. They're just like, we don't give a shit. They read Nick's motion and were like, yeah, these guys are going to lose. They weren't even bothered to waste their time. They have other things to do. Now, they point out, moving forward, acknowledging it's just Nick. So remember, now it's a one-sided argument. There's not even another side to argue with. The state's not there to shoot them down. It's almost like an open goal. The state was up there. They pulled their goalie. Chat. They didn't even bother to defend the net. And Nick and the Barneswalker, they got the puck. The court points out criminal defendants don't generally have the right to file an appeal until final judgment has been entered. But the court may allow an appeal from an order that's not otherwise appealable in the interest of justice. And you see these rules here, Minnesota Rules of Criminal Procedure. Then you see them citing the Minnesota Rules of Civil Appellate Procedure. These rules are important. These rules govern how you file things, the way things have to be done, especially rules of appellate procedure here, chat. Those are very strictly construed for the most part. Criminal rules, yeah, you could even then you have to color within the lines. Courts generally adhere to them. And there's tons of case law that flesh out your criminal rules, but your appellate rules are also fleshed out very well with a lot of case law, and courts are very stringent about that. You don't get to fuck around and color outside the lines on appellate court. You are stuck following the appellate rules of procedure. You're going to see why that's important and why I point that out. In determining whether to grant discretionary review, this court considers multiple factors that include whether the ruling is questionable. Like I said, is it clearly wrong? Or does it involve an unsettled area of the law? Meaning, is it a novel issue? We never dealt with it before. So it might be kind of important. The importance of the legal issue presented. Once again, is it something like the president arguing whether or not he's immune? And whether the issue would evade review if the appeal is deferred until the underlying case has been decided. Now, that generally, you can preserve the appeal. That's a very rare thing there, but it can happen. So, discretionary review is only extended to important legal questions that have broad applicability. The petitioner must also show a compelling reason for this court to grant discretionary review. And here's the issue. The petitioner does not explain why the district court's pretrial ruling denying the motion to suppress evidence and for a Franks hearing require this court's immediate review. They don't explain why. Why? You have to tell the court why. Like, why should you hear this? Why is this important? And notice, the Minnesota Rules of Civil Appellate Procedure. Okay? And it's requiring a statement why an immediate appeal is necessary and desirable. You didn't even follow the fucking assignments, chat. And here's the thing, they point out, Minnesota rules govern the procedure for an appeal. All right, so what does 105.2 say? You have to provide why you have to do this. I guarantee you this is not a brand new rule. Not a brand new rule. But this is why you have to know what you're doing. If you don't follow the rules, the court's like, I can't fucking help you. They also point out, moreover, this court generally does not grant petitions for discretionary review of pretrial rulings because the defendant can utilize the procedure in Minnesota Criminal Rule 26.01, sub 4, which permits expedited review of a pretrial ruling that is dispositive or would make a contested trial unnecessary. So they had another vehicle. They had another option, another vehicle to do this. Why aren't they doing it? I don't even know if they can do it now. Maybe they've waived that opportunity by filing this. I don't know. Nick could go ahead and show why he shouldn't be required to proceed by stipulating the facts and waiving a jury trial to obtain review of the pretrial ruling. Yeah, well, there you go. That's part of the issue. I don't think Nick would agree to the facts and waive a jury trial to obtain review of the pretrial ruling. I mean, how confident are you, Nick? But I don't even know if they could do this still at this point. It's not clear. And although review would be somewhat delayed by requiring petitioner to appeal from any final judgment, the pretrial ruling will not evade review. And a defendant's interest in avoiding the time and expense of trial does not by itself establish a compelling reason to extend discretionary review. Nick has not otherwise shown a compelling reason for this court to extend its discretionary appellate jurisdiction when the pretrial issues are fully reviewable in any appeal from any final judgment. Therefore, it is denied. Again. Although this court's nice, they kept it in lowercase and they didn't bold it, but like, denied by Susan L. Segal, Chief Judge. So what's he going to do? I don't know. He's got his hearing next week, and, it's man or mouse time, I guess. Mavka's right. How did Aaron compromise the Court of Appeals? You know what, though? Detective Pomplin and I, we drove down there after we planted all the cocaine. We drove down there, walked into the judge's office, and were like, listen, you guys, we like, here's the plan. And then we all sat down. I told them it, and they're all like, right on, fat man, right on. And then the one judge was like, hey, man, would you like to enjoy this, help me eat this sandwich? And I said, hell yeah, brother. So we sat there as a group just eating a sandwich together. It happened for real. And it really happened. It happened. Also with the Nick updates, I know there's been basically Nick's facing like issues of unauthorized access of Aaron's Google information, Google accounts, and all that. Yeah, that was really fucking dumb. Don't fuck around in computer accounts that aren't yours. I mean, it's like if you went to Starbucks and somebody left their laptop open, would you go, well, it's open, I just can play with it? No, you wouldn't do that. That's basically what Nick did. Apparently, Aaron, from one of the early days of being over there, had used Google, because everything you do with YouTube and all that and StreamYard, all that stuff's linked through Google. It all activates. Well, apparently Aaron said, yeah, can I use it here? The computer, and Nick kept it logged on. And apparently Nick has been, hoovering up data. And that's because Patrick Melton from Nobody Likes Onions, which it's not a good joke because everybody likes onions. Like everybody. Started talking about all the things Nick had access to and Nick had seen. Which, once again, Chad, I tell you, don't take notes about committing crimes and don't talk about committing crimes. And if you're joking, don't joke about committing crimes. Because guess what? The police are going to take a notice of you. And then they might find out if you're committing real crimes in the process. Either way, we learned some things. Apparently, Nick has been surveilling communications, such as, apparently, according to Melton, once between me and Aaron. And if Melton is right that there was legal advice in there, Nick, you're surveilling people who are trying to establish some basic relationships there. Are you really sure the Minnesota Bar wants to know you're surveilling attorney-client relationships? Something to think about. And because Aaron's probably talked to his attorney in Minnesota, I'm sure Minnesota doesn't want to know that some snake, and that's the type of person who would breach privileged communications. I mean, you'd have to be a slithering snake motherfucker. Like, just the most inscrutable, like, just insufferable snake slithering around piece of shit to surveil privileged communications that you're not supposed to. I mean, that's the kind of shit a bar will take your ticket for. But, I mean, what does privilege and confidence mean when you'll go out and blab about somebody's mental health crisis in the middle of a drunken rage? I mean, it shouldn't really shock anybody at that point. I'm just saying. Confidentiality is important to me. I've talked to you out there. I mean, so many of you have sent me emails and things like that and questions. I'll never reveal any of that. I never would in a million years. It's not mine to give away. It's not currency I use to extort and fuck with people. That's how real confidence works. That's how real privilege works. Orania says, would the state bar require conviction for discipline to intercepting communication? No. Oh, hell no. Your conduct in a case, like if you're representing parties, what you do in a court case can get you fucked. They don't need convictions. Convictions are helpful. But if he were to get reported for surveilling privileged communications of other parties, actually, they'll probably be able to stick their head up and they'll go, wow, we can fit like another whole head in here at the same time. This is really wide already. Shockingly so. Huh. Hello. I mean, like, I'm not going to lie. If I was on a case and I found out some jackoff was intercepting my communications with my client by being a little fucking asshole, I'd be going straight to the fucking bar. nothing I really can do here from Ohio, but like if I was Aaron's attorney, oh buddy, you bet I'd be looking to fuck Nick's ass with a shovel. I mean, that's unacceptable conduct for an attorney. Like his character and fitness is completely gone at that point. It is completely gone. The man cannot be trusted. He's completely unhinged. Like that would not be acceptable at all. Because if you guys have ever seen emails from an attorney, it says, if you're not the intended recipient of this, please notify the sender and please destroy this copy and any all copies of this message. Yeah, that's how privileged communications work. It doesn't mean, oh, here, I'm going to sit here and then I'm going to talk about it. Oh, da. So no, he doesn't need to be convicted. When you talk to the state bar, you go, well, do you know what the myopia of a specter is? No? Well, that's because you're just poor. That's not going to work. Your word games will not work with them. Aaron and his attorney have attorney-client privilege. Nick is a third party who appears to have intermeddled into that privilege. He's an interloper. Nick has surveilled that privilege improperly. He doesn't have privilege to do that. I would argue illegally as well. But even if it's not illegal, it's definitely improper and it's unethical, and that's against the rules of professional conduct. You're not allowed to go fucking around at things like that. So that's the issue. He violated other parties' privilege and confidentiality. Perestroika says ethical violations are very serious, and bar associations do not like trust in the legal industry being undermined. Yeah, and it's one thing to be kind of a spazzy lawyer out there doing stuff on the internet. It's another thing to be a complete off-the-walls lunatic, screwing with real legal matters. Like that, this is becoming number one, an embarrassment, but also just like people aren't going to this is something that would undermine the trust in the legal system. So I really hope it didn't happen, but it seems like it did. As far as he's in federal trouble, he's not in federal trouble, guys. Yeah, maybe in theory, maybe he violated the Computer Fraud Act, but they're not going to go after him. Do you know how much crap the U.S. Attorney's Office? Number one, they go for stuff that's really good and they can know they're going to win. Number two, they've got a ton of crap to deal with already. You have to really either be somebody the feds want really, really bad, or two, you piss someone off politically. And he hasn't done either of those things. So, yes, theoretically, could the feds come after him? Yes, just like the feds could go after every felon who is caught in possession with a gun. Do they ever do that? No. I don't see them getting involved. If they get involved, I will be happy to eat the crow on that one, because that will be fucking hilarious. But that's not going to happen. Of the list of things that are going to happen, chat, this is number one on the list now of things that are not going to happen. Natclo says, why do you think Patrick Melton committed a crime? I'm not sure if he has yet, but certainly I would not go joking around that I've had access to unprivileged and possibly illegally obtained information, because, well, now sounds like you might be involved as a conspirator, because it sounds like him and Nick had a close relationship. I don't know if they do or not, but there's going to be subpoenas for all that information. When you run your mouth about having inside knowledge of it, they're going to say, well, maybe you have information, Melton. And they'll subpoena his records and information, and I'm sure he doesn't want that. So you never brag about doing dumb shit, because you'll get noticed. Who would prosecute it? The state of Minnesota would prosecute it, because Nevada doesn't care. He worked with a guy in Minnesota, and now they're fucking with a guy in Minnesota. So, yeah, not a good fucking idea. Now, will they go after him? Yeah, maybe, maybe not. But it's still not. Why would you want to put yourself in police investigation? That doesn't. Nobody's ever like, oh, that's so fun. The police are hoovering up my internet data and my Discord and my Gmail. No, that's never a good thing. You don't ever want that. Don't ever tempt fate. Why would you say something? It's a statement against pecuniary interest. I mean, although what Nick would say would be an admission, but yes, even for Melton, yes. You wouldn't say these things unless they were true. Nobody in their right mind would admit to committing a crime unless they committed a crime. Generally the premise is you're doing something that's harmful to your interest. You wouldn't do it unless it was true. I mean, when they wrote this, they weren't like, what if some dumb fuck comedian goes and does it as a big work? It's all meant for it to be lulled. No, they're like, nobody would do that. So, guys, yeah, that's kind of the whole Rekieta saga for right now. It's from what I've heard from people, and I've heard some things from people talking about things. Nick wants to go to trial, and he thinks he can do it. I don't know how much, if he's huffing duster and thinks he can do this or what's going on here, but I really hope he doesn't think he can go to trial. Nick, I will give you sincere legal advice. You're not going to win. Your drug results came back. It's clearly cocaine. If it wasn't, you would have already been able to get this thrown out. It's coke. It's in your house. Buddy, get diversion, get a deferred agreement, get something. But this is not a hill to die on. It's not a hill to die on. It's a needless waste. And despite what lulls may be had, you are literally just wasting it. Don't do it. Really don't do it.